Welcome to the Court of History. I'm Sean Wilentz at Princeton, and talking with my compadre, Sidney Blumenthal, and our guest, Jill Lepore, talking about the Constitution, all things constitutional. I wanted to talk a little bit more, maybe shift the conversation from part one into part two, just talk about amendments. Because as you said earlier on, there are periods in American history where amendments come in a flurry, and then it disappears for a long time. And these are obviously critical moments in our history. And, the three that stand out are, of course, the 13th, 14th, and 15th Amendments in the Civil War, which have come under great strain. Well, not the 13th so much, but certainly the 14th. And, again, this is something where understanding where the 14th Amendment came from, not just with regard to birthright citizenship, but all of it, historians have a lot to say that that people ought to know, don't you think?
Yeah, and that the courts have been really interested in. I mean, that was the great turning point of Brown v. Board of Education, which was argued twice in 1952 and 1953, 54. The decision comes down in 54, but when Fred Vinson died suddenly, the Chief Justice of a heart attack, and Eisenhower appointed Earl Warren as the new Chief Justice, Warren decided, like at Felix Frankfurter, I think, had wanted to do this. I think Alex Bickle, his law clerk, wanted to do this, ask all the parties to answer some historical questions. And he sent around these 5 questions about the history of the 14th Amendment. Because there was a kind of lively scholarly debate at the time about what the 14th Amendment, where it really could come from, and what it maybe therefore what it meant. And when kind of I'm just you guys have a program called the Court of History. I assume your listeners know this, but what happens when the historical evidence comes in?
Tell us,
the segregationists and the pro-segregationists and the NAACP. I mean, there's a kind of great story about who is involved in doing that research. But when the evidence comes in, Warren looks at it, and Bickle reads it, Frankfurter reads it, and they all decide the historical evidence is inconclusive. And Warren decides, look, this is a decision we have to make based on the state of the world. Like, we have to just know segregation is wrong. And maybe we don't have to rely on history and tradition. If we rely on history and tradition for everything that we do, all we'll do is perpetuate the history and tradition of inequality and injustice. So we are the court of justice and the court of law. So we will, in fact, make this decision not as a historical decision. We will not defer to the original intent of the framers of the 14th Amendment. We can't even know what that is. And you know what historians would say? It's actually very hard to know what a group of people, what the 39th Congress as a body meant, what the people who are petitioning, the tens of thousands of petitions submitted to the 39th Congress, what did they think it meant? Like, there's the great uncertainty of the historical record that all historians understand. It is a partial, incomplete, biased. It's a very difficult body of evidence to contend with, and it requires interpretation. And Warren had the great, decency to recognize that was not what was going to determine the outcome of this case. But that, there's a lot of strong argument that is really where originalism comes from, because the guy who had this guy, David J. Mays, with whom I'm fairly obsessed. So David J. Mays had won a Pulitzer Prize in 1953 for a biography of Edmund Pendleton. He was a lawyer, an amateur historian, and he was a Virginian. And he argues the cases, one of the cases that gets consolidated is Brown v. Board of Education. And he's the one who does the research to show that the 14th Amendment was never intended to end segregation. And he's furious when he loses that case. He's argued many times against Thurgood Marshall in cases all over Virginia and the South. And then he becomes the architect of the campaign of massive resistance, under which, the solid South, refuses to abide by Brown v. Board of Education. And then he goes on to devise a theory of original intent. He gives a Senate, he gives testimony in Congress that is published under the title A Question of Intent. That is like a founding document of originalism. And it's really just an argument that he has devised to insist that Brown was unconstitutionally decided. And this original intent, originalism, just really picks up traction in the 1960s, largely through Mays. And if you go back, his diary was published just a few years ago. It's an extraordinary document. And it begins as a young man when he goes to his first lynching and talks about how exciting it was. And, then he goes with friends. He takes the train to DC to go see Birth of a Nation. Like, this is the person from whom we should take our understanding of how to interpret the Constitution. He is just a really fascinating character. And that fact that his diary even survives is a kind of weird accident of history. But yeah, I found him a really compelling
I think that's really an
actor to
important
follow.
insight, Jill, that originalism really begins in the reaction to Brown. And you also point out another figure, James J. Kilpatrick, who was the editor of the Richmond newspaper, who helped write the Southern Manifesto, which says that we need to get back to the original Constitution. And in some ways, this goes back to the Confederate Constitution that was devised. And as Jefferson Davis said in his inaugural address, that he talked about Dred Scott and the Roger Taney decision. He said it's explanatory of their well-known intent. So Jefferson Davis himself had his own ideas about originalism rooted in Dred Scott.
Yeah, well, and the pro-segregationists arguing before the court in oral arguments in Brown cite Dred Scott. That's a case that advances their claim because of its method of interpretation. They cite Taney talking about how important it is to defer to history and tradition and to the intent of the framers. It's not. This is not to say that originalists are trying to overturn Brown today. I don't mean in any way to suggest that.
Although they are trying to overturn the Voting Rights Act.
It is an unsavory pedigree.
Yeah. So I want to talk to you about something else that's also in the book, and it deals with the whole constitutional law and the amendments that come out of the progressive era, and the opposition to it. And there's a figure who you revive from history. He's a forgotten figure named James M. Beck, known as Mr. Constitution. And we're living in a world right now of another invented concept of the unitary executive and the idea that there's something called the administrative state that is somehow illegitimate. And the Supreme Court is ruling on all this, but it goes back to that period. And that's what they're trying to do, is roll back everything back to there. But tell us about James Beck and the Liberty League and his views on all of this.
Yeah. So conservatives were in good shape in much of the progressive era because the court was so conservative. So anything that Congress did, the court just overturned. So including in the 1890s, the federal income tax, which passed Congress in 1894. And then the Supreme Court overturned it as unconstitutional in 1895. So progressives facing that conservative court decided they really had to amend the Constitution. And they had in relatively recent memory, the 13th, 14th, and 15th Amendments. So they devised really a slate of amendments that they needed to get through. And so this alarmed conservatives no end, who then began arguing against amendment itself, right? Insisting that the Constitution was sacred, perfect, the framers were divinely inspired, right? The rhetoric of veneration that has been handed down to our day really originates in this kind of like 1890 to 1920 era. So 1924 is the first time a shrine is built to the Constitution. It's displayed at the Library of Congress, 1924. So Beck, who'd been Solicitor General, a lawyer for all the big trusts, he what really pisses him off is the year 1913, which is a really bad year for conservatives in the United States, right? Well, Wilson is inaugurated. The income tax amendment is ratified.
Federal Reserve.
Federal Reserve is established.
Trying to undo the Federal Reserve now.
Yeah. Socialists win mayoral offices all over the country and are inaugurated in 1913. Socialists in Congress begin calling for the abolition of the Senate. It's a really crazy year, but that's also the year that Charles Beard publishes the economic interpretation of the Constitution of the United States of America. Right. Beard had been well, I think he was at that point still at Columbia. He later leaves Columbia.
He's a historian at
His-
Columbia. Yeah.
Yeah, he
he's
leaves
still a
in
Columbia
protest
very
over
much.
loyalty oaths. Yeah,
Right.
very principled guy. But he writes this book in which he says, "Well, in fact, the Constitution, we should maybe venerate it because these guys are just protecting their property interests."
Right.
This is very progressive spirited, kind of like a muckraking.
Yeah.
Yeah, very much so.
Conservatives go nuts. Like they freak out about this book, which is a very distinguished work of scholarship that you could argue with. And, I think most historians would say he didn't really get it. He got some,
he got it wrong.
It was a really important
but-
contribution, but he kind of got it wrong.
But he started a good conversation. He really did.
Yeah,
Yeah.
started a really good conversation.
that's
But
going
he
on till
forms,
today.
I hadn't realized this, but Beard forms this committee to amend the Constitution in New York with a bunch of other progressives.
Well,
So
we
he
know
always
that,
said,
yeah.
my book didn't have anything to do with my progressive activism. I don't nothing to do with it. It's just
Yeah.
pure scholarship. And you're like, meanwhile, he's
Right.
they're actually having like weekly meetings drafting amendments.
Interesting.
So Beck is one of the people that freaks out about Beard's book, and he's like, I'm gonna write the conservative version of that book. And he writes this, it's almost like a catechism about how beautiful and wonderful and perfect the Constitution is. It's so it's so over the top. I mean, it's so sort of like Bill O'Reilly in a way, like in terms of like, do you know what I mean? Of just the tonally, like it's very insulting to a reader.
Yeah.
It's a harangue, and it's really devoid of much information.
It's
So-
it filled with
condescending.
condescension.
He's looking down at the
and it also
reader.
it comes right after fundamentalists. I think this fundamentalist book called like "What Would Jesus Do" is published in the 1890s, and
Yeah.
so Beck invents this,
Fundamentals
what
are
would
done in
the
19
founding fathers do, right?
Yeah.
And this is when they first are called the founding fathers. And now, we're betraying our parents if we amend the Constitution. So he opposes all amendments to the Constitution, except for the repeal of the 18th Amendment, which he supports. But so he just really works hard to to defeat the 16th Amendment, the 17th Amendment, which is the direct election of the Senate. He's opposed to women's suffrage. But he's on the radio all the time. He's like the podcaster of the 1920s. He's just out there in a kind of Glenn Becky way, I would say. I mean, but not really, because he's the former Solicitor General, and then he runs for Congress, and he ends a seat in Congress. So he's a very smart guy. But he thinks that his role is to dumb down the Constitution to force Americans to venerate it. And so what's necessary for Beck and all of these fraternal organizations that emerge at the same time, like the Sentinels of the Republic, is to insist that it's unpatriotic to question the Constitution, right? This is the age of the Sedition Act, right? There's just an incredible amount of fear of political dissent, fear of constitutional change, that all the winds seem to be blowing in favor of progressivism.
And he emerges later to oppose a New Deal too.
Yeah. Yeah, he's in Congress at the time, and he, is just red in the face, and then tragically then dies of a heart attack. I think just like the New Deal took his life away from him. He couldn't abide it. I mean, it just was like he would do the thing all the time of, oh, if the framers were alive today, they could not forfend. They would be devastated by the state of our country. It's become a socialist. It was socialist. We've become a socialist state. The income tax is the first step towards communism.
Right.
Yeah. And this all somehow gets synthesized, all these strands from the past in Bork. Robert Bork.
Yeah. Yeah. Bork, did you guys, either of you, ever meet him?
Sure.
Yeah?
Yes.
And?
I haven't met him, although my wife was involved with People for the American Way that
ran the ad campaign.
She was the.
He just seems like an
media
angry
director.
person. Like, was he like an angry person before 1987?
Yeah.
Oh,
no?
Yeah. When
Was he not?
Was at Yale, he was at Yale. He was at law school, so you'd see him. And he did have some interesting characteristics. He wouldn't he would have research assistants who were not conservatives. He didn't mind mixing it up. He had intellectual liveliness about him, but he had a. I mean, this was after he was Solicitor General. This was after Watergate. So there was a sense already that he was on the outs. And he was rather bitter.
Yeah.
And he didn't have lunch with a lot of people. Put it that way, in the law school dining room. But he made his mark, shall we say? I mean, everybody remembers him about Watergate, but very few people now. We get it back with your book. Remember that piece in 1971, which was really the
right. And then before Watergate, I was really. I find him a fascinating character. Most people.
What do you take away from Bork, Jill?
I think that I think we mistake originalism as being wholly a product of Bork when really Scalia was so important to it, and certainly, obviously, on the court. But I spent a lot of time thinking about that moment in 1982 when Bork students at Yale and Scalia students at the University of Chicago formed the Federalist Society. Partly because I found some interesting photographs, and I found the invitation, the program of the original list of speakers. So it was a lot of really interesting people, judges came to speak. But Yale students protested the Federalist Society at its first meeting in 1982. I found a photograph of the great legal scholar Mary Dudziak as a second year Yale law student, carrying a sign saying, if men had abortions, abortion would be a sacrament. Your sort of stock feminist sign. And there were students who protested that the Federalist Society was an anti-civil rights organization, and that's how they understood the name. And I just thought I had somehow. The fact that I think of the Federalist Society in the kind of Leonard Leo forward time, but not in that 80s moment when it was really kind of culture war among the law school students. And that was kind of fascinating to see and to try to imagine maybe how exciting that would have been for Bork and Scalia, who I think for Scalia, it was sort of nourishing to be on the outside fighting against the insiders. Bork, I think, resented it more, maybe, I would just guess temperamentally. But then to be the heroes of a new movement of young people.
Exactly. They had followers.
Must have been tremendously exciting for them. And then, when Meese steps into that role in the Justice Department,
Edwin Meese
becomes Reagan's Attorney General and declares originalism to be the policy of the Department of Justice, and it will be the litmus test for every federal judicial appointment. To have that constitutional revolution in so short a time. I mean, a long time if you're thinking about back to Brown, but a short time from 71 for Bork. The drama of it all. And then, I had forgotten too, when Bork, so Reagan then nominates, of course, Scalia in 86 and Bork in 87. And when Bork appears before the Senate Judiciary Committee hearings before Joe Biden is the chair, I had completely forgotten that it was actually the exact 200th anniversary of the Constitution. So all these constitutional parades are going on all over the country, September 17th, 1787. And there's Bork on C-SPAN saying, we can only use these documents. This parchment is the scripture. He doesn't say those things exactly, but I think I had forgotten about the power of that bicentennial.
Yeah, I had a question for you about Scalia in your view. Scalia is more or less the inventor of something that is a corollary of originalism called textualism. And to me, this is, turning the Constitution into a catechism. It's a kind of doctrinal Catholicism against the entire spirit of the Constitution, which, as you point out, after all, was written by Protestants who believed in religious dissent and freedom and were deeply opposed to religious oppression based in their knowledge of and experience of English history and the Crown. So Scalia is doing something very different with textualism here. of turning the words of the Constitution and enshrining them into dogma?
There's really there's just a lot of splintering among originalists. It's like Protestant denominations and the great effervescence of Protestantism. There are the Lutherans, there are the Methodists, there are the Baptists. I do think they all fall under one head. I think what's more interesting, and I certainly don't take this up in the book in any way at all, is how opponents of originalism, that is to say, legal scholars who are opponents of originalism, have not managed to offer up a successful way to talk about what they themselves do. Because public opinion surveys report resoundingly that Americans believe originalism must be the only way to read the Constitution. Because obviously any historian is going to look at a document, you're going to read the text, you're going to do a close reading of the text, you're going to wonder who wrote it, who they wrote it for. Like, these are all the first early questions that you have. They're perfectly natural. That those are the only questions that you have and the only methods that you apply is not natural to historical inquiry. But I remain fairly puzzled, but I guess this is broadly a question, that applies to the whole of the left, in the sense that nobody knows what the Democratic Party stands for, except that it's opposed to Trump right now, right? You're opposed to originalism, but what are you for? I think that I think that question hasn't been sufficiently answered by people who are opposed to originalism.
Yeah.
Well, suppose let me just throw this out there. Suppose you were to say, we had a system, we had a jurisprudential system, if you will, that was around for a very long time. It was about precedent. It was about all the ways that we went about doing things. There were differences, to be sure. There's something that seems to be, I think it's been a radical break. We ought to go back and actually be the true conservatives and go back to the way that we operated before all of this. Is there anything to that or no?
I mean, there's Holmes talking about, the Constitution as a living, breathing, organic thing. So.
Well, I think what conservative scholars would point to is, and they would say and have said, it's FDR who broke Article 5, right? It come 1935 when the Supreme Court begins to strike down the New Deal, overturning, the NRA, the National Recovery Act. FDR's advisors say, dude, we got to constitutionalize this thing. Let's run a slate of constitutional amendments. The progressives did 4 amendments in 7 years. Let's do 4 like tomorrow. Let's get this done. We have to constitutionalize this thing. And FDR says, okay, did you not see what happened with the child labor amendment? It passed Congress like on the day it was introduced in 1925, 1924, and it still hasn't been ratified because it only takes like $1 million to defeat a constitutional amendment in this age of mass media, and with like Southern textile mill owners determined to maintain a right to employ children, especially Black children in Southern textile mills. He and Eleanor have been really involved in the child labor movement, and he just looks at his advisor and he's like, there's a depression on. It takes years to get a constitutional amendment through and ratified, and it just takes is money to defeat it. Like, we're not going to do that. We don't have the time, and we can't defeat, the National Association of Manufacturers or whoever else is going to oppose our attempt to constitutionalize maximum hour, minimum wage, fair labor, banking regulation, the Securities and Exchange Commission, everything else that you'd want to constitutionalize. He's like, I'm just going to win the court. And he does. And he brazens it out and he wins. And so.
But let me just add, if I can interject, he gets it passed through the Congress. It's legislative. And that's constitutional too. So the Congress, plays a role here. It's not simply.
Yeah. No, he gets like the Fair Labor Standards Act through, but he also gets it through in such a way that the Supreme Court's not going to overturn it because he wins the battle with the Supreme Court, right? They blink, essentially. So, at that point, liberals just sort of decide. I mean, the civil rights movement has to go to the courts. They don't have the vote. They can't possibly do an Article 5 amendment. But liberals decide, for the middle decades of the 20th century, let's just enact change through the courts. So, there's a real empirical footing to the conservative critique of judicial activism. It's just utterly insincere, since once the conservatives get control of the court, they
become
do
the
same thing.
activists. Yeah, become the
Yeah.
activists. Right. Well, we come through a lot. We haven't solved everything by
So
any
much
means.
more to discuss, and that's why people should read the book too.
Absolutely. And
It's a quick
Jill,
read.
no, it is a quick read, actually, quicker than you'd think for a long book.
It's a quick read, and it requires rereading too.
They do, yes, exactly. It repays rereading. At any rate, consider yourself a friend of the court, Jill Lepore. We're here for Sidney Blumenthal, for Jill Lepore, and for myself, Sean Wilentz. The court is now adjourned.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.